Hello and welcome to my stream. What I'm going to be doing today is I'm going to be focusing on studying public law. The reason I'm doing this is I failed my first attempt at law about 6 years ago. I have since then obtained two other degrees, a undergraduate degree in the University of Bournemouth that was studying international hospitality management. And the second one I was studying was for a master's degree, which is an MSc at the University of Bath. That was studying operations, logistics, and supply chain management. In this, I'm just going to be going over some context related to areas of law. For example, I'm actually just going to be kind of sitting here. If you guys have any questions or anything you want to respond to, feel free to do so in the chat feature, which is available. And hopefully this will be readily available for you when you need it. So the paragraph that I've just written and read about has just covered the aspects to deal with how there is a three-tier system. So you have the government, you have the parliament, and the judiciary, which make up the decisions made within the country. For example, in the UK, some have written constitutions, so those will cover areas which specifically require you to focus and have everything, all the rules written down, and these will be changed and amended over time. However, in the UK, we don't have these. We have a set of laws which can be amended. However, they have to go through various chambers. They get debated, and they also have to pass through the House of Lords, and if there needs to be any amendments, changes will be then made. However, if it goes through all those processes, and this can take months or potentially years to enforce, then they get registered into law. These laws then get adapted to basically what's needed for the time, but the purpose of this is to stop the government from doing exactly what they want. The argument that some people make is, however, that when you have certain people from certain backgrounds, so high class, high privilege backgrounds, which judges normally come from, they sometimes are biased towards their own type of people. In this case, that'll mean they reflect very much what a conservative government may be thinking at the time, or potentially the same with some members of Labour also coming from a high background of privilege, in which case they will enforce those ideologies. The next chapter we'll be looking at will focus on constitutional rules in the common law. What this chapter requires us to look into is the fact that there are different levels of legislation. So, when you consider it this way, you've got legislation which can be repealed by any government, and that's just the situation it is. Sometimes there are specific behaviors that need to be uh, dealt with. So, for example, you've got higher crime rates to do with stabbings. As such, that's sometimes why they will legislate specifically for that offence, even though there is general guidance and rules. Sometimes it can be just to increase the sentencing requirements or to reduce the sentencing requirements necessary. So, for example, murder might be increased in terms of the number of years as a minimum sentence, or you could have something where for example, a few years ago, I think it was about 10 years ago, it was commonality that people were using acid attacks. And so there was a consultation as to whether that would increase. Whereas in certain cases, you have the example given that um, you've got certain basic rights that should be at that higher level. They should be protected. They should not be, abused by whatever government sees fit at that time. So the freedom of expression um, is um, is a viewpoint that's currently something that's being debated with the Public Bills Act. The ability to strike, whether there needs to be a higher percentage of turnout and voting required, and the use of a minimum service level for certain groups. These include the fire engines, the firefighters, police, and of course, for the NHS, nurses and doctors, whether they have to meet a certain minimum requirement, which would, of course, limits the impact of any strike action that would be taken by any of the unions. There is also, like I said, the freedom of expression has to do with if you don't agree with something, whether you should have the ability to put like signs up or to hold marches and demonstrations. This is a very dangerous alley to go through just because if these things are limited, this can create significant issues going into the future. This also looks at reviewing how the interactions between different groups are concerned with. So, for example, they look at how the government and the MPs within Parliament very much think the same. The idea is that the legal system is there to protect people with specific backgrounds and issues. So, for example, those who are from ethnic minorities who may not have the necessary legal understanding to take their case through to the courts, or to those whose opinions differ from other individuals, as a majority tends to be. So this chapter was focusing on how the interactions between the three different elements were focused. So, for example, with Parliament, the issues are if Parliament reflects too much in the direction of the government, then we're going to end up in a situation where laws are changed in order to help make their jobs easier and to curtail the freedoms of people. Whereas if they do so for legislators, then they believe that legislators themselves can become too powerful, too engrossed, and can then also become corrupt as they enforce what their interpretations of the law can be. Since the law, even if it's it's put into wording, these can be interpreted in various ways, and people can manipulate the situation depending on where their points of view lie. By having all three as the restrictions, they act as checks and balances as a way of focusing and protecting each other from basic corruption. That's the purpose. The next part of the chapter we're looking at is basically 1.5. This is looking at the constitutional conventions. It says here that conventions are defined as rules of constitutional practice that are regarded as binding in operation but not in law. Among the particular conventions discussed include Section A, which is by convention, the sovereign does not become publicly involved in party politics of government. For anyone who isn't aware, the sovereign is basically the crown state. So you're looking at the Queen and now the King, as this book was from 2016. So this is, far before the Queen has passed. So this is now taking into account that the royal family don't get involved in political matters. As it is, you've heard of things such as when King Charles was Prince Charles, he used to view and express opinions based on the environment, anything to do with climate change. And he, at that time, even then, was questioned as to how far he could go with it. And nowadays, he is not so much allowed to do so, given the level of influence that he has. The roles of the Prime Minister and Cabinet are governed largely by convention, which means they cannot do exactly what they want. They have to follow general guidance, general practices. And if they were to enforce any sort of rule changes, this has to go through the Parliament's checks and balances systems first and be agreed to by a majority before they could enforce this. So this is why sometimes getting things through Parliament can take years. By modern convention, the Prime Minister always sits in the House of Commons. This means that directly relatable that he can be challenged. So unlike the House of Lords, which tend to discuss with each other and they'll have expertise, they don't tend to get too involved unless they are that subjective, in which they will throw out policies if they need to. Whereas with this, it's, the Prime Minister's questions are held on the Wednesdays. This is where you can, if you're interested in, actually watch it live to see how the government is being challenged by the shadow parliament. So that will be the direct opposition. So in this case, since you've got the government that has been Conservatives for the last, I think it's 12 years, it's 12, 13 years coming up for, it's the Labour government which is challenging what they're doing. And it says here, there is convention that an individual with a minister only, if they are there is a convention that an individual will be a minister only if they are a member of the House of Commons or the House of Lords. So they have to have been voted in at first. So this is why you have different constituencies. So one might be Labour, one might be Lib Dem. So they cannot have an overrule within the entire, for example, country. You've got different regions who might vote differently. And this is why there is such a big deal of when certain areas go for their by-elections, because they might completely change the direction of who they're voting for. By convention, cabinet and cabinet committees take decisions which are binding on members of the government. So this means that if a decision and a law is made, and decisions are made in that actually go against the government. Unfortunately, the government has to stick to those rules unless they're able to challenge this. Sometimes this goes through the courts. Sometimes this actually just goes through the House of Commons. The two houses of Parliament acknowledge various conventions governing the relationship between them, including in relation to primacy of the House of Commons, financial privilege, and the operation of the Salisbury-Addison Convention. Not too sure about that last point. I'm sure I'll read up on that at some point in the future. In terms of the financial privilege, as you are aware, they had the whole bonus schemes scandal that happened a few years ago, in which members of parliament were taking backhanders and they were taking money for whatever they were doing. They'd be doing undeclared jobs and these wouldn't be taxed. And so there were issues with that. So whenever a member of parliament has to take, another bit of a job, they have to declare this, and any financial interest they have, I think it's within 6 weeks of actually receiving the money or at least doing the job. And if they fail to do so, they are then put into a meeting and asked why they've forgotten this. You've had MPs from all across the board who've had these issues. Labour MP David Lammy had this issue. You've had Conservative members who've had this issue. You've also had issues to do with how some MPs have, for example, attended the cabinet, claimed their £300, which is, I think, more so for the Lords as peerages. They've gone to wherever, and then they've suddenly ended up, at home, which is like 3.5 hours away, and they've not actually sat there. They've just signed the register that they've taken the money, that they've attended Parliament, and haven't actually done anything. And as for the relationship between the House of Commons and the House of Lords, House of Commons has the overall say in the direction of decisions. However, they will seek guidance from the House of Lords, who are experts within a range of fields, everything from nursing to law to engineering and everything in between, sciences, maths, the economy, teaching. They have the variety of skills. In 2011, the government acknowledged that a convention had developed in Parliament that before troops were committed, the House of Commons should have an opportunity to debate the matter, and said that it proposed to observe that convention except when there was an emergency and such action would not be appropriate. So this relates more so towards the issues to do with the war in Afghanistan and the decisions that were taken by Tony Blair at the time when he was a Labour government minister. He was the prime minister at the time, and he made these decisions at a point where we're finding out now, and even a few years ago, that these should not have been taken without further discussion. Of course, there are cases of emergencies, for example, the issues currently happening with Ukraine, which may ask for or demand more immediate responses, which is fine. At this case, this allows that to happen without having to necessarily debate that. So now we're going to be reviewing areas involved, including codes. So these are small subsections in relation to specific articles in law, also referred to as concordates. Most, perhaps almost all conventions now exist in written form of various kinds. Different parts of the government systems have from time to time set down in writing the principles and key aspects of practice governing their relationship, called memoranda of understanding or concordats. These are, in essence, agreements to create a convention or a set of conventions to regulate a particular relationship. The driving force for the creation of a concordat has often been constitutional reform, devolution, changes to the office of Lord Chancellor, and alterations in the role of local authorities. Such examples include in October 1999, the UK government and the governments of Scotland, Wales, and Northern Ireland signed a memorandum of understanding, the latest version being September 2012, agreements on the working of the Joint Ministerial Committee and concordats on issues such as coordination of EU policy and financial assistance to the industry. In January 2004, Lord Wolfe, or Lord Chief Justice at the time, and Lord Falconer of Thoroton, who is Lord Chancellor, negotiated arrangements on the principles that should govern the future relationship between the judiciaries of England and Wales and the minister responsible for judiciary-related matters. And in December 2007, the UK government and local government association agreed the Central Local Concordat to establish a framework of principles for how central and local government work together to serve the public. This was applied to England and Wales. These concordats are regarded as political in character and were not envisaged by those who made them to be enforceable by the courts. It is a statement of political intent and should not be interpreted as a binding agreement. It does not create legal obligations between the parties. It is intended to be binding in honour only. The courts may view this as an unattractive argument that one party to a carefully negotiated agreement should be able to breach it with impunity. What is the constitutional status of concordats? So that's where the question lies. How relevant are they? And where do they lie in terms of their importance? Okay, so this next section is reviewing should the UK adopt a written constitution. The previous one looked at dualist theory, the idea that there are two concepts that are constantly fighting each other. The area of concern in that case is whether local governments could take enforcement action versus those which are already agreed in international treaties. Even if a country hasn't necessarily signed up to those treaties, do they have the ability to overrule those? In an example that they gave in this case, it was looking at it was to do with benefits, and it was about restructuring them based on the number of kids a person has. So if they have more than, I think it's two kids, their benefits would be limited to a certain level. Three mothers took the government to court because they were claiming that actually it marginally, disproportionately affects women who are single mothers and are therefore not in a situation to dictate a further income. So it says here the case for a written constitution that has been stated. The purpose of this is that it would allow everyone to know what the rules are and which institutions were that the government and direct ministers, civil servants, and parliamentarians in performing their public duties. So it clarifies their positions. The sprawling mass of common law, since there's so many laws out there, surrounding the number of important but sometimes uncertain unwritten conventions, makes it very difficult for the normal person to understand and needs to be replaced by a single document or a basic a sheet with all the laws dictating the working and operation of the government in the UK, which should be made accessible for everyone. It should be a public document. Further to this, it's become too easy for governments to implement their own decisions and reforms to suit their own needs and basically throw these into legislation. The present unwritten constitution is looking too much to the past. It doesn't actually take into account current affairs or issues which need to be addressed as of now. I know, for example, areas of technology such as AI are needing to look into more concerns, social media, anything to do with hate speech. These are all common factors which are becoming more globally concerning and need to be addressed by various governments of various international standing. It's unavailable and ineffective for the 21st century, as it says, and the aspirations of people going into the future. It fails to give the sovereignty of the people and discourages participation in the parliamentary process. So the argument is that the more people are kind of shut out of the conversation, the more difficult it is for them to speak up and to address what their issues are and how they can manage them. It also says that this would also clarify our position a lot more with international partners. So, for example, we do a lot of trading with France and Ireland and the rest of Europe, and we need some clarification, and they need clarification as to what we're doing and as to what they're doing. Now, the case against a written constitution is sometimes it can be considered as unnecessary. The fact that the UK system of government has never been reduced to a single document shows the success that various governments have gone through whilst stabilizing the country. This is in direct contrast to other countries who do possess written constitutions, who have looked for their own independencies. So, for example, Catalonia, I think, which is a part of Spain, has wanted to make their independence known, and have thus far been refused. It's more flexible and approachable if you want to adapt laws for current times, um, as you can just change those so long as they go through some sort of process. It's understandable. There are a number of different factors which actually keep public protections in place. So these include the shadow cabinet that exists. So that's the government in waitings, the opposition, or you also have the judges who can make changes in accordance to what they need. It would also, if you had a written constitution, it would make a lot more paperwork for the judicial system to justify any decisions they make. There's the last point, as it might destabilize the country because people won't necessarily, know what's happening with the situation, and there are certain laws that we're not aware of, or maybe I'm not aware of, that will have an impact. But because it's a bit like, if you aren't aware of it, you can't be concerned about it. As soon as something has been written down, you see it, and you kind of have that fear about you. So they have looked at discussing three alternatives to a written constitution, which would make it easier to apply this in principle. The first, constitutional code. This would be a document that's been advised by the parliament, but without the statutory authority. This is just sets out the essential existing elements and principles of the constitution and workings of the government. So just understands what their processes are. Second option is a constitutional consolidation act. So this will have a stream of the most important laws for the country to follow, common law and parliamentary practice, with the codifications, so you understand a little bit more about how various laws work. And the third option would be the written constitution, which would just have a draft of all the basic laws which the UK is governed by. This will be in relationships between the state and its citizens, and a process of an amendment document should anything happen, and if it needs to go to a more updated version. Okay, so as just concluding comments, we were looking into the direction of how public law has been enforced, whether there should be a written constitution or whether it's fine as it is within the United Kingdom's context. As you can see, the arguments for the written constitution include that it just makes it clearer as to how the policies work and as to how people should be interacting with the law. The concerns with doing that are that it's quite rigid and it would need various forms of adaptation across various years. I would imagine you need a new public document at the end of each year just to make it relevant to people. And so it would have to be very easily accessible. It would also be quite costly to do so. You would have to agree within Parliament as to the most effective laws and which ones you need to follow. And of course, that is where the expense comes when you have civil servants who will have to write that out and then to publish the document. There would also need to be various forms of checks and balances to make sure that has been written correctly. In terms of if you have an unwritten code, it does kind of give more flexibility, as has been the case when certain forms of criminality or certain behaviors have happened and increased. Governments have then had to go through Parliament, so there are due balances, checks and balances to protect the citizens of this country. But the only concern with that is that people then aren't aware of kind of laws that you're following. I mean, we do have some very ancient laws. Apparently, there's one to do with not getting a fish drunk. So you can't have living fish in, I don't know, beer, for example, swimming in beer. It's a very old law. You've got things from Magna Carta, you've got things from 1066, very ancient laws in this country that probably don't need to exist, but for whatever reason they do. And we just kind of have to live by them. I don't think necessarily this country is actually quite good at not punishing its citizens for very obscure laws. It's just so long as you're aware of the main laws, I think you tend to be fine. So, me coming from a food industry background, I'm aware of like temperature controls, health and safety legislation, making sure to be hygienic, anything to do with that, allergen management, everything basics that I need to know to operate in a food safe environment. So that's fine. Keeping chemicals stored away in a separate area from the kitchen. All of these are very basic requirements, very easy to handle, very easy to manage. So that's fine in my circumstances. And so long as you're aware of what you have to do, you tend to be fine. Thank you very much for watching, and for anyone who does attend the replay, I hope this was useful. I will be doing probably more live streams of this. It's just as study motivation. Don't consider that, he's discussing or looking into sections of law. It's just a class to help kind of keep people motivated. I know January tends to be quite a bad month. I'm just going to put something here in the chat to say thank you for the so thank you. This is to help motivate you for your exams. It doesn't matter which subjects you are taking, as this is just for just a support group. Okay. I'm just going to put that in the chat. There we go. And thank you very much. And I will see you in the next one.